I came home to find my yard repurposed by other people with paint still drying as if someone had decided my life was just a suggestion. That's the short version, and it's the one I wish I could hand you in a tidy envelope, but the truth is, messier and better. So listen. My grandfather built that dam in 1952, stone-faced and stubborn, 180 feet of compacted earth and limestone quarried from Buncombe County, two 36-inch cast-iron slide gates set in by hand, a machine as much as a memory. He built it to hold Drum Creek for the farm. His hands turned the cranks, then my father's, then mine. For 70 years it did exactly what it was supposed to do. Quiet, reliable, a little proud. I left for a forestry contract in the Pacific Northwest for 16 months. The kind of work that eats your calendar and spits out maps and muscle memory. And when I called home the first few months, I got Burl's practical clipped updates. Burl is the kind of man who doesn't like to text, who uses a camera like a ledger, who knows every crunch of the gravel road into our place. His early messages were small and plain. They're grading your east field. Contractor back. Little alarms that sat like pebbles in my pocket until they started to rattle. A laminated trail map with orange blazes. A laminated trail map with orange blazes showing a 1.2-mile loop that cut across my timber-crossed Drum Creek twice and put footbridges where my creek had been left to do its job. There were benches, two dark green park benches set right in what I knew by the feel of the land and by the line of stakes my grandfather had paced out to be the dam's inundation zone. I stood on the crown of the dam, hands still smelling like diesel from the truck, and I looked down at my own land being used as a park. My gates were where they'd always been set to winter flow, and for a long minute I'd just listened wind through the tulip poplars, the distant laugh of people walking a trail on ground that wasn't theirs. I called my attorney Sylvia from the patch of road where Burl had told me the fence had been moved. She answered on the third ring like always. "Don't approach anyone on the property today," she said. "Photograph everything. Get a survey in the week." Days he brought me more than 200 days. He brought me more than 200 photographs, survey stakes, a Caterpillar D6 in my brush line, the fence relocated 80 feet inside my recorded boundary, the grading, the asphalt, pour the little hand-scrawled label on a delivery truck. Each photo had a time and a note. He'd started a notebook, dates, GPS coordinates, equipment serial numbers, like a man building an argument with a camera instead of a pen. The story they told was plain on paper. Ridgeline's board had voted to improve the Eastern Strip, a $187,000 amenity they called the Eastern Green Space Initiative. 2 board members had tried to stop it. Spend $3,000 on a survey, they had said. The president overruled them, took a landscaper's word for the line, hired a contractor, and went ahead. That alone would have been sloppy. What pushed us into the realm of willful was a letter buried in the HOA attorney's file, a short, clear note from their own counsel in August, telling the president in plain language, "The county records show this parcel belongs to another owner. Get a survey." If the survey confirms that, stop. He didn't stop. He went full steam to the November completion. That's the twist in the middle of the story, the moment the story flips from weird mistake to choice. It's the one that makes you see the whole thing differently. This wasn't ignorance. It was expediency. The man who'd built houses for a living decided his instincts were a substitute for a survey, and when given a written caution by an attorney, he paid set it aside anyway. We filed. Sylvia moved methodically. Boundary survey, county recorder documents, FEMA maps. The plat was sealed. Every bench, every blaze, every bridge post sat squarely on the Drummond parcel in deed book 847 page 312. The county floodplain overlay put that footprint in Zone A, E 100-year floodplain, meaning you can't grade, fill, or build without permits, engineers, no-rise certifications. The Army Corps' National Wetlands Inventory flagged jurisdictional wetlands under the parking base. And then the clock that hadn't been ticking for me because my job had always been to steward the land, not to litigate, it started running fast. Marcus Webb, the engineer, we brought in, made a simple but brutal case, a public park. Placed in a registered dam's inundation zone changes the hazard classification. A low-hazard dam that fails into undeveloped land becomes a significant hazard if people use that corridor regularly, benches a 24-space parking lot, a trail used by hundreds of households. That triggers licensed inspections, updated inundation mapping and emergency action plan. and tens of thousands of dollars, maybe up to $140,000 in compliance costs for the registered dam owner. The cause, the HOA's choice to build where they had no right to. It's one thing to argue about property lines. It's another to be facing regulatory reclassification, federal wetland enforcement, and the technical machinery of dam safety all at once. We serve documents on the HOA. The Wilmington District of the Army Corps sent a notice, unauthorized, fill in wetlands, unauthorized fill in a FEMA floodplain, unauthorized structures in a waterway removal and restoration required no retroactive permit. The NC Dam Safety Program issued a reclassification review. Our Superior Court complaint laid out 5 counts: trespass by permanent improvement, unauthorized floodplain development dam, reclassification damages, unjust enrichment, and punitive damages tied to the HOA president's knowledge. What I didn't expect, what I hadn't anticipated when I stood on the dam and looked at the benches, was how the scales would tip. The HOA tried the old maneuvers, adverse possession arguments, appeals to community benefit offers, to pay to keep the park. But the law is not easily rearranged to reward willful blindness. The HOA's own counsel had told them what to do. They chose a different path. That mattered. The county put a temporary escrow hold, $90,000, on the HOA to fund the inspection and mapping while the case ran. That's when the board started to creak. 2 members who had been skeptical from the start produced meeting minutes that showed they asked for a survey and were overruled. Our discovery pulled the HOA attorney's letter handed to their president in August, and it became Exhibit F. The punitive damages claim wasn't rhetorical. It was a record of a man who'd been told and went ahead. Negotiations tried to slice the problem into manageable pieces: trail stays, license agreements, checks in exchange for preservation. But there were facts that couldn't be negotiated away. The Army Corps' order couldn't be bought off. The federal compliance had its own timeline. A license wouldn't erase the reclassification, nor would a check fix the encroachment. In the end, the only practical resolution that satisfied all 3 tracks, civil, federal, and regulatory, was removal and restoration. They milled the asphalt, hauled out the gravel base, tore up the path. Substrate unbolted the footbridges and pulled the driven footings with hydraulic tools, relocated the fence back to the recorded line, planted a native seed mix, and handed the benches and the carved sign to the county surplus. Nothing dramatic, just work that put the corridor back to being what it was: brushy, irregular, a functional floodplain doing its job. The Army Corps issued a compliance certificate. The state's dam safety program rescinded the reclassification after the occupancy was gone. The escrow paid the inspection costs. The HOA paid remediation and restitution. Warren Gill lost the board presidency, and Helen Pratt, the woman who had once said, "Spend $3,000 on a survey," ended up elected by a wide margin. Burrell's notebook closed with neat final entries, dates, photos, a small satisfaction in ink. The ending felt like justice, not showy, not punitive for its own sake, but precise, like setting a displaced fence back to where the survey said it belonged. There was relief in the ordinary rhythms, returning the creek running at its bankful, the dam gates at their winter setting, the limestone face solid in the low winter sun. On a cold morning in January, I walked to the spillway with Burrell. He asked, half joking, "You ever actually going to open them all the way?" I looked down the corridor, the seed beds, catching the first green, the fence back where it should be, and I shook my head. "No," I said. "The paperwork did it." He nodded like a man who knows which tools are for which job, and sometimes the law is the right tool. If there's a lesson here, it's not about land only. It's about stewardship and humility. My grandfather didn't build a dam to assert dominion. He built it because someone had to manage water for the farm. He respected the creek's business, and he respected boundaries. What surprised me, hurt me most, was watching a small, neat idea called improvement become a machine that made trouble when applied without curiosity for whose land it actually was, without asking, without the decent step of a survey. Arrogance is expensive. It costs money, and it costs trust. The hard lesson I keep is that stewardship is not a one-person thing or one generation's job. It's a promise you keep by asking questions before you act. So here's the part I want you to think about and tell me in the comments because I'm dying to know where you come down. When a community invests in what it thinks is a common good but gets the land wrong, what's the fairest remedy? Is removal and restoration the only just answer, or should there be a place for compromise that keeps improvements but makes the liable parties pay for the risk they introduced? Share your story if you've ever had a neighbor cross a line, literal or legal, and tell me what happened. And hey, if you liked hearing how one stubborn dam and a very stubborn caretaker helped set things right, hit like, subscribe, and drop your location in the comments because small towns and stubborn people make the best stories, and I've got more of them.